Thanks to all of you for being online. Appreciate you being here, and thanks to our team from our corrections unit for the good work they've done in this case. As you all know, we offered oral argument in this case in March, and we're pleased to have the ruling today, and we're pleased to have a unanimous ruling from the state Supreme Court upholding the trial court and dismissing the appellant's arguments, finding that the constitutional claim against the three-drug protocol is moot, and dismissing their non-constitutional claims concerning the legislative delegation of authority and the Uniform Controlled Substances Act. From here, we expect to be able to move forward depending on what the three appellants decide to do with further actions. And John Samson can explain what will happen in terms, in particular, of Cal Brown's execution date. But again, we're very pleased to have a unanimous opinion from the state Supreme Court, and I want to thank the team for the great work they've done on this case to date. John, do you want to add any comments?
Thank you, Rob. The team here at the Department of Corrections Division is pleased with the court's ruling. We've contended all along that the department has complied with the law and acted in a lawful manner, and will do so in any future execution, and we will move forward from today.
Very good. Sarah, thank you as well for your work on this with John. Questions?
It's Rachel at AP. So the date, assuming no other legal interference, September 10th, is that correct?
Yes. The court's order today says that the stay granted for Mr. Brown is lifted under a Washington statute. When the court lifts the stay, the date of execution automatically resets for 30 court days, and September 10th would be 30 court days from today.
Scott Sunday with the PI. I'm curious about other appeals. I'm wondering if he has other appeals, Cal Brown, in the federal courts, if he's already exhausted his habeas corpus.
He has exhausted his federal habeas remedies. The court has denied relief on that, and he would be barred from filing any new federal habeas petitions. He's also exhausted his state court collateral challenges to his conviction and sentence. In this case, he could file a petition for certiorari with the U.S. Supreme Court seeking review of the federal claims in this case today. But the mere filing of a petition for certiorari will not stay the execution. He would have to get an order of stay from either the Supreme Court or the U.S. Supreme Court. He does have one case that is technically pending in front of Judge Kunauer up in Seattle. That case was filed at the same time the state court case was filed by Mr. Brown, and he may attempt to reinitiate that action, although it's the state's position he would be barred from challenging his execution in that proceeding since he's pursued this issue in state court.
Talk a little bit, this is Rachel again, about where the other two cases stand for Gentry and Samson.
Mr. Stenson has a stay issued recently by the state Supreme Court in his 6th personal restraint petition, and Gentry has a stay issued by the federal court. Those cases are unrelated to the case that the opinion came out today, and their date of execution is not affected by today's decision because of those other stays, and they will not have a date of execution until those other two stays are lifted.
Any other questions about the case? Thank you, everybody.